Hi, my name is Jenny Walters. I'm an attorney with Clink Skills Elder Law Practice, and today I want to talk about a topic that's maybe not very exciting, maybe a little uncomfortable, and that's having a will. And maybe making it a little more interesting, I'm going to have a very low-tech game of true-false to explain some of the misconceptions and talk about some things that a will can do that you probably aren't aware of. So first of all, a will is only to name the beneficiaries of my property. False. A will can do a lot of other things. It's obviously very important to name the beneficiaries of your property. But in addition to that, one of the most important things I want to mention is that if you have children that are minors, young, under 18, then a will is where you need to name who is going to be the guardians of those kids should something happen to you. So that's a really important thing that has nothing to do with the beneficiaries of your property that a will does. And I'm going to get into some of the other things as we go. Next, this is a common one that I've heard. I have a will, so my property will not go through probate. False. A will, for your property to actually pass according to your will, that means it is going through probate. And probate is the process where you, to put it simply, you file your will with the court, you have an attorney prepare documents to basically get court permission to transfer those assets to the beneficiaries. And it's a process that can take about 6 months. You probably need to pay an attorney to prepare the documents. And so that leads me to my next question. Probate can be avoided. True. So it's important to have a will to name your beneficiaries. And like I said, if you want your beneficiaries named in your will to receive your property, one way to do that is to go through probate and have the court oversight so that your executor, who is the person that is in charge, can transfer those assets. But there is a way to transfer assets to your beneficiary that has nothing to do with probate in the court. So even though it's good to have a will, you can also avoid the probate process by naming beneficiaries on your bank accounts, having transfer on death deeds on your real estate. Now there's some pros and cons that come with that, so it's not something that you want to do without some considerations, and which leads me to my next question. Probate should always be avoided. False. In a lot of situations, we like to avoid probate. It's just extra time, extra headache, extra expense. But in some situations, probate can actually be a good thing. If there's a situation where court oversight would be good when assets are being distributed, there's also some special circumstances when we have a married couple and one of them is long-term care where a probate can be a good thing, and I'll get to that. I do not need a will. Everything will just go to my spouse anyway. This is a big one, and it's false. So here's the example. If one spouse owns some real estate and it's only in their name and they do not have a will, that leaves everything to their spouse. If they pass away, that property is going to pass according to intestate succession, which just means without a will. And it could end up going half to the spouse and the other half goes to the kids. And this happens. And we have a recent example of that. And so that's where a will would become very important to make sure that everything goes to your spouse, because it's not automatic depending on how things are set up. A will never needs updated once in place. False. It's important to have your will done, but and it's it can be a good tool for that period in your life, but as you go, as situations change, most likely it needs updated to account for those different situations. If somebody's in long-term care, if somebody's become disabled, you need to update your will to have extra provisions for those circumstances. A will can protect assets for a disabled beneficiary. True. Sometimes people feel like they maybe need to disinherit a disabled beneficiary because they're on government benefits and they don't want that money to have to be spent on care. Maybe they need to leave it to another sibling. But you can actually have provisions to protect that property and have it held in a special kind of trust to protect it for that beneficiary instead of it just getting dumped in their lap and being exposed to long-term care costs. Which leads me to, a will can protect assets from long-term care costs. True. And that applies not only to that, let's say we have a disabled child, but really importantly, if we have a disabled spouse. This kind of goes back to, once you have a will done, should you ever update it? And so one really important example is if we have a married couple and one spouse is going to need long-term care, and if we do Medicaid planning or not, and most likely with Medicaid planning, we'd shift all of the resources to the well spouse. But what happens if something happens to that well spouse? It doesn't necessarily make sense to dump everything back to that disabled spouse, the spouse of its long-term care. So in the will, we would want to have some special provisions that if that well spouse passed away, then the disabled spouse would only inherit what the law said they would need to, but then the rest of it can be protected. And so that's a really important tool to have in that situation. Finally, I do not have a lot of assets, so I only need a will, not a trust. Maybe. That may be the situation if we don't have any special circumstances. A will may be all that person needs. Maybe we avoid probate. But I'm going to leave that a little open-ended because we're going to be doing another video about trusts, and that will help explain in what situations a trust can be helpful regardless of how many assets there are. Thank you.